Senior Felix, we are ready when you are.
Okay, thank you so much, Fatah. Um, First of all, let me confirm, can you all hear me and clearly?
Yes, we can hear you.
Okay, thank you very much, Yakubu. Okay. So my name is Aboagye Felix Adofo Esiama. I'm your colleague in part two, and I'll be taking this session, which will be on civil procedure. I want to start with this introduction. When we were in part one, we got two pieces of advice that really affected or that really helped us with our approach to all the subjects that we had to study in part one. The first one was given to us by Yao Opon, Mr. Yao Opon, our Director of Legal Education and Director of the Ghana School of Law. And his advice was, I want to share it because I think it would also benefit you guys, that in or at the Ghana School of Law, you must do one thing. You must cease to see yourselves as law students and now begin to see yourselves as lawyers in waiting. So you are professionals at the final stage of your apprenticeship to become professionals. So instead of learning the law as students, as we did it at the faculty in a theoretical way, you must begin to see that everything that you are learning here in part one, and for that matter later on in part two, is the practical or the theoretical side of what is supposed to be a practical aspect of your profession. So the more you see the practical aspect of the principles you are studying, the more part one and part two will come to life. But the more you begin to look at it the same way you study the law at the faculty, the more you will struggle. So that's the first piece of advice. Now I have another piece of advice which is relevant for civil procedure. And this will be found in an article that is written by a lawyer called Bobby Banson. So Mr. Bobby Banson was the one who taught me and my colleagues civil procedure in part one. He's currently the lecturer for the post-core group. And he has an article which is titled Of Roots and Branches. And this is what he says in the first paragraph of that article. I'm going to share the article with Fatah so that he can make it available for those of you who have not yet seen it. And this is what he says in that first paragraph. He says, if your knowledge of substantive law is brilliant and you have no knowledge of the rules of courts, then you cannot be a proper lawyer. These were the words of Justice Enim Yeboah of the Supreme Court of Ghana when I first met him sometime in 2009. In his estimation, and like those of many legal courtroom practitioners, a good lawyer must know the rules of courts by heart. So in this discussion, my objective is twofold: for you to appreciate civil procedure in a way that would help you learn the course and pass your exam on one hand, and on the other hand, to understand that if you really, really want to become a lawyer or a professional legal practitioner, then you cannot run away from procedure. It is indeed procedure that really makes you a lawyer or stand out as a lawyer. Without procedure and just the benefits of the substantive law, you will be more like an LLB holder and less than an actual lawyer. Okay, so civil procedure is not something that you should run away from. It's something that you must not only understand, but try and enjoy, because that is really what all our practice is about. It's really about mastering the procedure. Okay, now I'm going to share what will be probably the most important thing I would say in all this discussion and even in the future discussions. Okay, so civil procedure is just five things. Civil procedure, notwithstanding whatever you may have heard, whatever confusion you have, I'm just saying that the good news is that civil procedure is just you understanding five simple things. Now it gets better. Even for these five things, there are two that you should already know already before you come to part one. And if you do not know these or you've forgotten them, there is opportunity for you to revise them. So I'm going to take us through what these five things are. And these are going to be the outline for all the sessions that we would have. So the very first thing that civil procedure is about is this. Now, we must first remember that civil procedure is the procedural aspect of civil litigation. Okay, so it's more like a subset of the more broader concept of civil litigation. And the very first thing you must understand for you to understand procedure, or for you to understand what you must do as a lawyer conducting civil litigation, is what we call a course of action. A course of action in a civil matter. So that is the number one thing. I'm going to take all of them, so don't worry. The second thing is what we call jurisdiction in law. I'm sure the first two things sound very familiar. Now, the number three is where procedure proper begins. Let me know if I'm going too fast, and if anybody has a question while I'm going on, you can raise your hand and interrupt me. Okay. Now, so number three is where procedure proper begins. And number three is how to initiate a civil action. Number four is what to do after you have initiated the action. And then, or what to do during the proceedings after you've initiated the action. And then number five is simply after you have obtained judgment, how do you enforce and execute the judgment? Or on the other hand, if you are aggrieved by the judgment, how do you file an appeal? If anybody tells you that somebody is a great lawyer when it comes to civil litigation, it means they are a master of these five things I have mentioned. It is impossible to be a great lawyer without being a master in all the five things that I have mentioned. And these five things that I have mentioned are the only things that civil procedure is about. Nothing more. So if you think right now that you have a weakness in civil procedure, I'm saying that your weakness is in one of these five things, or it can be all of these five things, and there is a remedy for that. Okay, so now let's begin with the number one. What do we mean when we say a course of action? Now, for number one and number two, before I discuss number one, for number one and number two, these are points that are found in what we call the substantive law. Okay, the substantive law is what you spent all those years at the faculty learning. So by the time you obtain your law degree, you should have a substantial knowledge of the substantial laws of Ghana. Now, number one, what we call a course of action is an injured right that entitles a person to a remedy in law. So you would remember that even before you wrote your entrance exam and you passed, some of your friends who are not, who are lay people who do not have a law degree may have come to you at some point and said, so I have this issue. Maybe I have a piece of land and I have the proper title to it, but I noticed that some other people are encroaching upon the land. Is it a matter that I can take to the court? Even without being a lawyer or coming to the Ghana School of Law, your response would have been yes. It's something that you can take to court and it's something that the court can deal with. But I'm sure that even before you came to part one, if any of your friends had come to you that, see, I had a dream last night and a ghost slapped me in the dream. Is it a matter that I can take to court? I'm sure the overwhelming response would be, no, this is not a matter that you can take to court. Because there's no course of action that allows you to seek a remedy in court for a ghost slapping you. Now, the good news about a course of action is this. Not only does it show you the beginning of what you must do in the law in terms of your civil litigation, it also introduces you to who will be the parties with you in that action. Because if I accuse Fatah of encroaching upon my land, then definitely if my course of action is against Fatah, then he's the party that I'm going into the action with. So if anybody says that they have an issue understanding who is supposed to be a party to their action, I sometimes believe that the issue is from a more fundamental place of understanding what the course of action is, which is the number one thing that you must understand when it comes to civil procedure. Now, if you've forgotten, maybe with time, we've forgotten about all these principles of course of action, all you have to do is to go back to the substantive law and revise. You remember, for instance, that if you go into a contract with a company and the company breaches that contract, it is not an employee of the company that you sue. All these matters come to the course of action, and the course of action are always related to almost always, in fact, indeed related to who would be the parties with you in that action. So that is the number one thing that you must know very well before you start studying your civil procedure. So it may be that a lot of people are complaining that civil procedure is difficult, but their problem is not really a procedural problem or a procedure problem. Their problem is more fundamental, how to really identify a course of action in a matter. So when you become lawyers too, clients are going to come to us. They are going to tell long stories or short stories. By the time the client is done telling you their story, you should be able to tell whether they have a course of action in the law or not. Your failure to determine this thing cannot even make you go beyond the first threshold, the first important requirement that you must meet to be a great civil litigation lawyer. So that's the first thing. Now, the second thing that you must know, even before you came to part one, which should guide you in how you study civil procedure, is what we call jurisdiction. Having determined that somebody can go to court, now the issue is to be able to tell that person which court has the mandate to hear that matter. The mere fact that you have an issue does not mean that you can walk to the Supreme Court and then request to see the Chief Justice and ask the Chief Justice to help you resolve the issue. We have courts in Ghana, and all the various courts have a jurisdiction. Now, the good news is that even if you've forgotten about the jurisdiction of the court, and for this matter, the civil jurisdiction of the court, you only have to refer to two documents or two authorities, the Constitution of Ghana and then the Court Act, to revise and then to come to terms with what is the jurisdiction of each of the courts that are in Ghana. The other thing is that the CI 47 is predominantly about the High Court, is indeed about the High Court, so it's the High Court rules. So typically what you have to know for the civil procedure class will mainly be about the jurisdiction of the High Court, sometimes about the Circuit Court and then the District Court. Okay, because the Circuit Court and the High Court share the same court rules. And then for purposes of matters like appeal, the District Court must rely on the High Court rules. Okay, so that is number one and number two. Now, number three of the 5 things that you must know to excel in civil procedure is how to initiate an action. Now, this is something that you would not know from the faculty. You would know number 1 and number 2, but it's in the Ghana School of Law that you must understand how you can actually file an action in a civil suit. So by the time you are done with your degree, you can advise somebody on whether the person has a course of action, which court has jurisdiction, but you would likely not be able to tell the person about how you are going to file that action. And that is where procedure begins. So procedure begins from number 3. It will continue from number 4 and number 5. So number 3 is how to initiate the action. Now, number 4 is having initiated the action, what to do during the proceedings. That is what number 4 is about. And number 5 is simply when you have obtained judgment and the judgment is in your favor, how do you enforce and execute the judgment? Or on the other hand, if you are aggrieved by the judgment, how do you file an appeal? Now, it is possible, the point I want you to see just from the 5 points that I have mentioned is this. By now, you should be very strong on number 1 and number 2. And the less you know of number 3, number 4, and number 5, the less you'll be confident about going to court. Because the less you know about how to actually initiate the action, the less you know about what you do during the proceedings when you are in court. And the worst of it all is you can go through the whole process of initiating an action, or in fact, starting from number 1, identifying the course of action. Number 2, knowing which court to go to and going to the right court. Number 3, actually initiating the action. Number 4, conducting yourself very well during the proceedings. But then, because you do not know about how to enforce a judgment, you cannot give your clients the fruits of the victory that you have won for your client. And there is no way your client will be happy with you because you know from stage 1 to stage 4, if that client of yours cannot get the fruit of their course of action. So every weakness in one of these 5 things is fatal to either your passing of the exam or to your practice as a lawyer. So anytime you see a lawyer who says they are shy about going to court, it simply means that they are deficient in one of the 5 things that I have mentioned. And that is the only reason why they don't want to go to court. And the less you know about procedure, the more you want to stay away from going to court. There are times that you would also hear about a fake lawyer who has been arrested. But typically, these are people who would have some good knowledge about the substantive law, because the laws are all available. What they will usually be lacking in is procedure. So you can also look at the analogy that the less you know of procedure, the more you are like a fake lawyer, or the more you are like just an LLB holder. That means that your coming to part 1 and part 2 would not really serve you any purpose. Okay, but the more you see the lawyers that you admire, the great lawyers that you want to become like, and believe that you want to be like them, then the more you must understand that procedure should be your thing. There should be nothing like, for me, I don't really get the procedure. You must enjoy it. Not only must you understand it, you must enjoy it. Okay, so now this session is going to begin from really the procedural aspect, which is the number 1, how to initiate an action. But before then, let me give a bit of a background, which would really situate the context, because I'm assuming that since you already have the law degree, you would understand how to identify a course of action, and then how to know what jurisdiction is, or which court has jurisdiction, the mandate of the court to be able to hear a matter and determine it. And I've already defined course of action to be an injured right that entitles a person to a remedy in law. Okay, so we are coming to the point of how do you initiate an action as a lawyer or as a student when you are given a paper and you are supposed, and it borders on how to initiate the action. What are you supposed to think about? Before I answer that question, I want to give a bit of a background. Now, I've already explained to you that point 1 and point 2 are about the substantive law. And as we all know, court rules are enacted under subsidiary legislation. Subsidiary legislation are not equal to the substantive law. We do not compare, or acts and the constitution or constitutional provisions are not on the same level as CIs, EIs, or LIs. That's why they are called subsidiary legislation. So there's this primary debate or primary dilemma that if the subsidiary legislation, which has the court rules, are not equal to the substantive law, and then the person has been given a right under the substantive law, which is enforceable by a court which has a jurisdiction to give the person the fruit of his course of action, then should rules or court rules be able to defeat that course of action if the person breaches any of the course of action, especially considering that these court rules are subsidiary legislation. So the question is that, should the effect of breaching a CI or a court rule be equated or deny a person the course of action that the law or substantive law has given to that person? Now, to settle it, case law tells us that court rules are only supposed to be handmaids and not mistresses. They are only supposed to facilitate the processes by which we obtain the fruit of our action, which has been given to us by the substantive law. And they are not really intended to defeat those actions. However, if your course of action is wrong in law, or if your number 1 is wrong, then you do not have a right to go to court. And if you cannot identify the court that has jurisdiction, then you do not have a right to go to court. However, when it comes to court rules, the point is that when there are breaches under the court rules, the effect should not be so drastic. So there should be either the opportunity for the court to allow the party that has breached the rules to amend those breaches, or in the worst case scenario, they will be set aside. So in order 1, we learn about the reasons why we have court rules. We have court rules because it is not just enough for us to have the substantive laws that tells us if somebody's land has been taken unlawfully, the person can go to the high court. But then there must be rules that gives us certainty and predictability when it comes to how we actually go to court and what will be the benefits. So we learn about things like the fact that under order 1, that It helps avoid unnecessary expenses. It helps for the final and effective determination of all the matters in dispute. So anytime you're thinking about why you need to learn about court rules, your first order or the order that you should be looking at is order 1. Then, as I have said, the idea is not that the court rules should generally deny a person a course of action that has been given to that person under the substantive law. So even where there is a breach of these rules, Order 81 becomes the saving grace where the court will be allowed to look at whether that breach is of such a nature that we can allow it to be corrected so that we can focus on the merits which are in the substantive law and deal with the matter, or is of such a nature that no, we should not give this party the opportunity to abuse the court processes and we then set aside that action. Okay, so the breach of the court rules in themselves will not render an action void, but it will only render it irregular and for it to be set aside. That is why we say that court rules or breaches, when there are breaches relating to natural justice, the substantive law or jurisdiction, the court rules cannot save those actions because those kind of breaches arise in the substantive law. Now, there are also procedures that are in the substantive law. So it is not only the CI 47 that has rules on procedure. For instance, the Constitution will tell you that if you have an election petition, if you want to bring an action which borders on an election, you come by a petition. That is a procedure in the Constitution. So if you breach that procedure, to the extent that that procedure is found in substantive law, it does not come under the principles of the CI 47, even though it is a procedural rule. I hope it is clear to this point. Okay, so now we are beginning from point number 3, because like I said, point number 1, which is the cause, knowing and understanding the course of action in a civil matter, and knowing that this is a matter that must be dealt with in a civil matter and not in a criminal matter. Then number 2, understanding the civil jurisdiction of courts in Ghana are things that you should already know about from the faculty. If you are not too settled on those things, you can go back to the substantive law and satisfy yourself. So with number 3, the first thing you want to know is how to initiate a civil action in Ghana. I've already described or I've already explained or touched on Order 1 and Order 81 already. The last order of the CI 47 is Order 82, which simply says that the rules in the CI or the court rules as you find in the CI 47 are not exhaustive, that common law rules would apply where there are gray areas. So already we have discussed the alpha and omega of CI 47, that's the beginning and the end, Order 1 and Order 82, as well as Order 81. Now we are starting on point number 3 in the 5 points that I say you are expected to know in order to master your civil procedure. That point number 3 is how to initiate a civil action. And to know about that, you have to go to Order 2. Okay, now for all the orders that will be relevant to helping you understand how to initiate a civil action in Ghana, you need to understand or have a fair understanding of Order 2 from Order 2 to at least Order 25. You will notice that as long as you don't have a fair understanding of these orders, you will be struggling in many things when that comes to the foundational things about the procedural aspects of civil procedure. So what does Order 2 say? Order 2 simply tells us that the default way of commencing civil actions in Ghana is by a writ of summons. Now, there are actually 3 ways by which you can commence a civil action in Ghana. The first one, which Order 2 tells us is the default way, is a writ of summons. The second way by which you commence a civil action in Ghana is by a petition. And then the third way is by what we call an originating motion or notice, or originating notice of motion, or originating application. I'm sure that in subsequent discussions, you would get to understand why we have this long name for that particular means of initiating the action. Personally, I prefer to call it an originating motion or notice. That is how the lecturer who taught me preferred to call it for a reason, and I'll share it later on. And that's how I also prefer to call it. Some people also prefer to call it an originating application, and you see why people prefer to call it that way. But Don't bother yourselves with the other two. Let it suffice for now that there are 3 ways by which you can initiate a civil action in Ghana. It is by a writ of summons, a petition, and then an originating motion or notice. And amongst these 3, the default way is by a writ of summons. That means that when you are in doubt, at least think about a writ of summons. And then the rule of thumb is this: until a provision of the law has specified a particular procedure by which you must initiate a civil action, you must initiate it by a writ of summons. So the writ of summons is the one thing that must preoccupy your thoughts when you are thinking about civil procedure. And that's why you must master that writ. The good news and perhaps the bad news for you in part 1 is that you are doing internship. So some of you may be seeing how the writ looks like in real life. But the bad news also is that the time that you would have to learn these things from the CI may be limited because you are spending so much time at the courts or at the law firms. But you try to see the brighter side of it. So the point is that anytime you want to think about how to initiate a civil action, the first thing you must think about is the writ of summons. And the principle is that the writ of summons is the authority, the document that compels the other party to join the action. And it must always be served with, so it's 3 things. It must always be issued together with the statement of claim, filed together with the statement of claim, and then served together with the statement of claim. There are other things that you must know about the contents and other things when you have time, so you read it under the order 2. The purpose of this session is not to discuss every detail, but to help you situate everything that you are learning under these 5 things and then learn it that way. Okay, so if you hear that there's an issue, you have been presented with an issue and it borders on how the party commenced the action, then you must be thinking about order 2, or whether the means by which the party commenced the action is the right procedure that has been provided by law. Okay, so that is it for order 2. Now, order 3 tells us about the venue. Typically, the difficulty that people have when it comes to order 3 is that they confuse it with jurisdiction. But that should not be your problem after this session, because I have told you that there are 5 things that you must know under civil procedure. And the number 2 is jurisdiction. It is under number 3 that we begin procedure. So jurisdiction has nothing to do with procedure. When we talk about venue under order 3, we are talking about something, a rule that helps facilitate the hearing of the matter. And we are not dealing with jurisdiction, which actually goes to the substantive law or the roots of the matter. Okay, this is why I'm recommending that you should read the article that I spoke about at the beginning of roots and branches. Because when there's an issue with the roots of a tree, it can easily be pruned away and the tree will survive. But if there's an issue that goes to the roots of that tree would not survive, it will die, because that is at the foundation of the tree. Okay, so jurisdiction goes to the root of a matter and it cannot be saved by CI, because jurisdiction is provided under the Constitution and under the Court Act. But when we talk about venue, we are talking about means by which we facilitate the matter or the hearing of the matter. So considerations as to in which place must the matter, or which court. So you know that we have only one high court in Ghana, whether it is the High Court Tamale or the High Court Accra or the High Court Kumasi. But then, for the purpose of convenience, let's say you live in Accra and then somebody lives in Kumasi, and then you want to bring an action against that person and you are filing the suit in Accra. Imagine the inconvenience that you are bringing against this defendant. And it may well be that this defendant at the end of the case is even innocent. Okay, so we are saying that the venue or order 3 is what helps us determine which venue to bring the matter. Okay, so if it is an immovable property, then definitely where that immovable property is located is the issue. That is why even when there's a breach with regards to the venue, the issue, you don't enter conditional appearance. It is still unconditional appearance. And then you bring an application for the court to seek leave of the Chief Justice to transfer the matter to the appropriate court. And in fact, if you are not even bothered about it, let's say that the person has brought the matter to a high court in Accra, and technically it should have been brought to Kumasi, but it's convenient for you, then there's no need for you to even bring an objection. So that is waived and then the matter is heard. because the whole import of the court rules fundamentally is to facilitate the hearing of the matter. Okay, so this is how you should be thinking about the things broadly speaking. Now, order 4 is about the parties. I told you that many times the struggle that people have with procedure is not really about the procedure. It's because you have a fundamental problem from your point 1 or point 2. That is your ability to identify a course of action or your ability to identify the jurisdiction of the court. So for instance, if I give you a scenario where I tell you that a party, Mr. A, entered into a contract with a company, Company B, and the company has defaulted on the contract, and that party A has sued an employee of this company, you should know that in company law, the company itself is a person, and the course of action and the privity of contract is between A and company B, and not between the employee of that company. Okay, so your struggle here to identify who should be the party to this action is actually because you have an issue with identifying a course of action. And you have an issue understanding that when it's about a company, your company law probably is deficient or is not allowing you to see that the company itself is a person. So in this case, your issue is not a procedural issue or it's not civil procedure. Your issue is in the substantive law. You must cure it from the point 1 and make sure that your point 2 is right. Once it is right, then you would know that because under in company law, the company itself is a person, then if the company has offended somebody, then and the person is the plaintiff, then the company must be the defendant. So this is how you know about the parties. So you can, as long as you have identified the course of action, as long as you know the jurisdiction, you should not be struggling with who should be the proper parties to an action. Okay, but when in doubt and to know everything, all the details about who would be the parties and what the parties must do, we look at order 4. Okay, so you see, the whole point is not so much about memorizing every single rule of order 81, of CI 47, because sometimes even the great lawyers that we admire do not have every single rule in mind. But what they do know is exactly where or under which order to find a particular issue that they are looking for. Okay, so now another thing that people also have an issue with is joinder of parties. Okay, am I able to share? Let me see if I can share my screen in a second. Okay, so let's do joinder of parties now. Okay, please, can you all see my screen? Can anyone respond? Let me know if you can see my screen. Hello,
Yes,
can
Council. So
anyone?
it appears you are sharing the, I don't know, the Zoom. Okay, yeah, it's we
Okay,
can
do you see my screen now?
Yes, we can.
You can see my screen. Okay, great. Okay, so now this is how you settle that issue of joinder of parties, and I'm going to discuss this issue of parties together with what you call the third party. Okay, just a second. Give me just a second. Okay, so if you can all see my screen, right? Now, when there is an issue, a civil action, there's a person we call the plaintiff. Okay, now this plaintiff claims that he has a cause of action against a person who we call the defendant. So the claim is like an arrow. Can you all still see my screen?
Yes, Council.
Great. So the claim, okay, it's like okay, someone's microphone is on.
Do Shadrach.
Yes. Okay, great. Okay. So if you can all still see my screen, okay. So you see, anytime the plaintiff throws his arrow, which is the claim against the defendant, we have what you call a claim. So it is the claim that is contained in the statement of claim. Okay. If the defendant says that he has a defense or a shield against this arrow, so I'm drawing a shield in front of D. I hope you can all see that shield. The line in front of D is the shield. If D says that he has a shield against that arrow, we call that shield a defense or a statement of defense. Please, is everybody following? Can you all see my screen?
Yes, please.
Yes, you can say counsel.
Thank you.
Yes, we
Okay.
are.
Okay. Now there can be a situation where D says that not only do I have a shield against the arrow or the claim that this plaintiff is bringing against me, I also have my own arrow against them. So, for instance, someone says that B owes him 100,000. Okay. And B is saying that not only do I deny that I owe A 100,000, but he instead owes me 50,000. In this case, he's not saying that he only has a shield, but he's saying that he also has a claim against P. So what you call that a counterclaim. Okay, pardon my handwriting. Okay, so in this case, D is saying that I don't just have a shield against the arrow that has been thrown against me by P, the plaintiff. I also have an arrow, which is a counterclaim, an arrow from the D going back into the direction of P, the plaintiff. Okay, now if another person, there is another person that P can throw the same arrow against, then that person is also a defendant. And that person can be joined to this action. Okay. And if that person is not a part of this action, then there can be an application for non-joinder. Okay. Now, in a case where a party has been added by P, but P cannot realistically, or P has no cause of action. Remember this cause of action again that I've been mentioning from the beginning. You see, it's a fundamental thing. If you have a problem with that, your problem is not civil procedure. Your problem is substantive law, and until you cure that problem, you will always be blaming civil procedure unfairly. Okay, so if P does not really have a cause of action against D, then D it cannot be a proper party to the action. So a party to an action is a person whose presence in the action is required for the effective or the proper and efficient settlement of the action or all issues in dispute. Okay, that means that if there is no cause of action between P and this second D, then D must not be a party to the action. Okay, and you must bring an application for misjoinder so that it can be removed. So this is how you understand claims and counterclaims and then defenses. Now there can be a situation where the arrow has been thrown by P against D. Okay, D is not saying that he has a defense. D is saying that this arrow that has been thrown against him, he also has that, he can also throw that same arrow against a certain person whom we call the third party. You see, so you see that there is no privity of contract between P and then this person, but there is privity of contract between D and then this person. And this is how it happens. Now, in our everyday lives, a lot of us have contracted an artisan before. Okay, maybe let's say a carpenter or a plumber who has come to, you have a fault and then you call a carpenter to come and fix it. Then the carpenter tells you that, oh, I'm going to do it for you, okay, but there is a wood specialist who has to do a particular modification on the wood before I come and fix that particular problem. So you pay the carpenter 100,000 and he's supposed to come and fix that issue in a week. As we usually experience, after a week, this carpenter does not show up. So you call the carpenter and say that, why have you not come to solve the problem for which I have paid you? And he says that, oh, master, it is not me, oh, the one who has to refine or do that special thing on the wood or spray that wood has not done it. And that is why I have not come. And then typically you say that, see, I don't have any issue with that person. My issue is with you. You are the one that I gave the 100,000 to come and fix that problem. So for as far as I am concerned, you are the one that I have the problem with. In this case, or in this scenario, what you are essentially saying is that I can only bring my claims against you as D. So D is the carpenter here. So whatever issue you have with that person, it is between you and that person. So that person will be a third party to this matter. Now, in civil litigation, there are occasions where the court can allow that third party to join the action so that it can settle all the disputes together. But there are many cases that the court will say, no, the real issue is between the plaintiff and the defendant. And so we can sort it out. And then later on, the defendant can take the matter up between himself or herself and that third party. And this is typically how these third party actions arise. So let's say that you have done an insurance policy with T company here. Okay, then you negligently drive your car into the car of P. So in this case, P has a claim against you. He has a cause of action against you because you have unlawfully damaged his or her property. Okay, so P can bring a cause of action against you. You can take out a writ and throw that claim against you in the form of the arrow. In this case, you don't really have a defense. All that you are saying is that the arrow that has been thrown against you, you can also pick that arrow and throw it against your insurance company, who is supposed to have insured you against the claim that P is bringing against you. So what you are saying is that you don't really have a defense against P's action. Okay, here, you don't really have a defense against P's action, but you can also bring in the third party, that is T, and then the third party can answer to the claims that P is bringing against you. So at all times, the preview of contract or the preview of the action privity of the action is between P and then D, but the third party is not somebody that P directly has an action against. Okay, by virtue of this defendant, P can also actually erect an issue against the cause of action that P has. So that is how you must understand joinder of actions and then third party actions. Okay, when you are thinking about joinder, you must remember that there must be a cause of action between the plaintiff and those defendants. There can be as many as 1,000 defendants. The rule of thumb is that there must be a cause of action. Your number one should have been ticked, that there is a cause of action in law between P and that person. Okay, you cannot, and when we talk about cause of action or a proper party, we are not just talking about people who are interested in the matter. So let me use this scenario to clarify. Let's say that D is married to E, okay, and then as can always happen, E is the wife, okay. So or let me use W, okay, so that you can see it as the wife. So this is the wife here. W, okay, W, okay. And then the wife has given a loan, marital loan, let me put it that way, okay, to her husband, 100,000 cedis. Then the husband went to give it to this carpenter, okay. Now the husband is unable to pay that loan. So you can see that clearly it is true that the wife is interested in this action that involves a husband and the carpenter. But the wife is not a necessary party to the action. We don't need the wife to be a part of this action for the action to be determined. And there is no privity of contract between the carpenter and then the wife. The privity of contract is between P and D. Okay, so sorry, I'm mixing it up a bit. So in this case, this is the party that gave the carpenter the money. So the carpenter will be here. So the carpenter is a defendant. Okay, so the plaintiff who has the wife. Okay, let me remove W. So this is a plaintiff who has a wife. Guys, again, and I said if something is not clear and if I'm saying something that you are not getting, please raise your hand or just unmute and ask the question. Okay, so P is the plaintiff and P has a wife. So the wife is interested in the action, but the wife cannot be a necessary party because there's no cause of action between the wife and then the defendant. The cause of action is between the plaintiff and then the defendant. So if the defendant also has a spouse, there is no privity of contract between the plaintiff and that spouse unless the plaintiff can demonstrate that there is some form that cause of action also affects that person. So imagine that there is a case where under that same transaction, the plaintiff gave 50,000 to this person as a carpenter, and then gave another 50,000 to this person as a plumber, and it's about the same construction issue. Okay, so in this case, the law or the CI allows the writ to be brought against these two people as a defendant because it's the same transaction, and then the plaintiff gave the plumber 50,000 and gave the carpenter 50,000, and it's around the same course of action because it's the same transaction. Okay, so instead of suing the carpenter in one action and waiting till it's done before it goes to sue the plumber, it can bring the course of or the action against the two of them in the same matter, because probably the contract that was signed was even signed between all of them, that you would do the plumbing works and then you would also handle the carpentry. Please let me know if there's any question at this point for the parties. And then the joinder of actions, and then the joinder of, we'll come to joinder of causes later, okay? But this is the joinder of parties. Is there anybody who has an issue here? Is it clear for everybody?
Yes, please.
Okay, great. So now we go to, so that was order 4. Okay, so now we go to order 5, which talks about what we call disabled persons. Now, remember that in law, the people that we call disabled are not people like, or natural people like a company. A company, after incorporation, has full capacity as any individual natural person. In fact, the disadvantage of natural people is that you are supposed to have reached 18 years before you obtain capacity. But for the company, right after incorporation, it has a beard. It is of full capacity, or if it's a woman, it is of full capacity and can do everything that a full-blown woman can do. The point is that in the case of a company that has been incorporated, it is not a disabled person. And also, a physically challenged person is not a disabled person in law. A physically challenged person is still a person of capacity. The persons that we refer to as disabled persons are minors, and then people who have an ailment that affects their ability to mentally to bring up an action, or such an ailment that affects them, or a bodily ailment that would impair their bringing an action. So even if the person has a disability, a physical disability, that does not prevent them from filing an action. They are not disabled persons. Okay, so you must understand that a company is not a disabled person. So order 5 tells us about principles or rules that guide how you bring an action on behalf of a disabled person. Okay, so when you read it in detail, that's how you are reading it for. So there's anything that is bordering on disabled persons in law. Remember that we are not talking about just physically challenged people, okay, or natural persons. A natural person like a company can be of full capacity, or is indeed of full capacity right from incorporation. So the point is that when a human being is born, the human being has to wait for 18 years. When the company is incorporated and the certificate of incorporation is issued, from that day, that company can enter into a multi-billion-dollar contract. It has that capacity, okay, and it's not a disabled person. So please remember this. Now, order 6 talks about partnerships. You can read about it further, okay, and what you should know when it comes to partnerships. Order 7 is about service. Now, when we began, again, I spoke about the number 1 thing that you should know in civil procedure, which is the course of action. Number 2 thing, which is the jurisdiction. As part of the course of action, I told you that you also get to determine who are the parties to that course of action. So anybody who says that they believe that they have a course of action but cannot identify the parties to their action are as good as a person who does not have a course of action. If you are saying that somebody has encroached upon your a piece of land, there must definitely be that person must exist for you to be able to bring an action against that person. Okay, you may not know exactly who that person is, but by all means you must find that person, and that person is your defendant. Okay, now when we say that once you have identified that your course of action is against someone, the point is that you must bring the issue to that person's attention so that the person can also answer to the issue that you are bringing against him. Under the substantive law, these are things that border on natural justice, that the person that you are having the issue against is entitled to know the issue that you have against him, and so that he can respond to it. But the procedural aspect is where order 7 comes into play or into view. Order 7 says that the means by which you bring it to the person's attention, the procedure by which you effectuate that course of action, or that principle in the course of action, that the principles of natural justice requires you to bring it to the attention of the person, is where we come to, or what we determine the procedural aspect of that thing or that principle under, the point 1 is what we find under order 7, which is under the point 3 of the 5 points that I've asked you guys to really pay attention to when it comes to civil procedure. Okay, so when we are talking about order 7, we are not really talking about, it is really derived fundamentally from the principle of natural justice. That means that you must take every proper step to bring the issue to the attention of the other person. That is why personal service is so important. Okay, because it will be fair and it will be contrary to the principles of natural justice that you are saying that you have an issue against me, or like as we often do, somebody will say you have an issue against you, but they'll be telling a third party instead of bringing the issue directly to you so that you can also bring, either put out your defense or your own counterclaims, or if you also want to bring a third party into the issue, you bring your third parties. They will now be taking the issue to somebody who is not really a proper party or must not be joined to that action. Okay, so Order 7 says that if you have an issue against, once you have the cause of action, you have identified the jurisdiction, there is a means or a procedure by which you bring that action to the attention of that person. Then we now go to Order 8. Order 8 talks about service outside of the jurisdiction. Okay, now the laws of Ghana, as we find in the substantive law, again, remember that a civil action itself is founded, is rooted on substantive law. Procedure is only how we effectuate it. The laws of Ghana, as we learned from the Court Act, the jurisdiction of Ghana, again, I've mentioned the word jurisdiction, which is number 2. That's why I'm saying that procedure is like 80% substantive law before the procedure itself starts, because the principles are originally founded or rooted in the substantive law. And the principle is that the jurisdiction of Ghana or the laws of Ghana is territorial. That means that the powers of Ghana or the laws, the powers that the laws have is within the jurisdiction of Ghana. The writs, which is the symbol of the authority of Ghana, therefore should not naturally have power outside of Ghana. So if you have a cause of action, yes, the cause of action happened inside this jurisdiction. That means that the matter can be resolved within this jurisdiction. That means that the court would have jurisdiction to determine that course of action. But then the party whom you must serve is outside of the jurisdiction. Then you must pay attention to Order 8, which gives you the principles as to how you can bring that action to the notice of that person who is outside of the jurisdiction, which involves you bringing an application first of all before you issue the writ, because the court must be satisfied that that course of action originates in Ghana. That means the number 1 has been satisfied, your course of action. Again, you see how we keep on coming back to number 1 and number 2. If you keep on running away from number 1 and number 2, you will only be deceiving yourself that you have an issue with civil procedure. Your issue will not be with civil procedure. Your issue is something that you failed to learn at the faculty, and not an issue that you have in part 1 or in the Ghana School of Law. Okay, so once you see all those things, go and make sure that you are touching on all those things. Okay, so so typically Order 8 is supposed to let you know that you are supposed to bring an application. There will be time for me to discuss what an application is. It's part of the orders that you must know fundamentally between 1 and 25. Okay, so the Order 8 requires you to bring an application first to seek leave to issue that rate, and having issued the rate, it is not the rate that you serve, but a notice of it outside the jurisdiction. Okay, and it is in practice, I'm informed that it is one application that you serve to do both things. That is to issue the rate or to take out the rate and then to serve the notice of it. Okay, so that is something that you should pay attention to when you are reading. When you are reading Order 8. Okay, now let's go to Order 9. Order 9 talks about appearance. So you see that from the discussion that I'm having with you guys, for each of the orders, there are things that you must principally know, or you must at least know that if the issue is about how the person is served, then you should not be reading, say, Order 11 or say Order 1 to understand that. That means that for you to understand what has gone wrong, then your knowledge about that particular order that deals with service is something that you should know about. If the issue is about the person being served outside of the jurisdiction, then that means that you should know about the order that deals with it. Okay, so essentially by now, what you should focus on really understanding is what do these orders generally deal with? Okay, and make sure your point 1, that is your ability to identify a course of action and all the matters that are related to it. Then your ability to understand what the jurisdiction of the court is, and all the matters related to that are settled. Okay. Then once you take every order, generally understand what goes into it. Then when you now read it, you are now building on or deepening your understanding. So you don't start with in learning the CI 47, you don't start by chewing them. You start by first understanding what the principles are about, and then once you do that, you now take your time to now understand the rules, one rule after the other, and then as many of the rules as you can learn. Okay, so we now come to 10. Now, order 10 talks about default of appearance. I want to discuss order 10 and then 13 together. Okay, so you remember that I had said in the beginning
So
that,
Felix, it's
sure,
order 9.
Fatah, please go ahead. Yeah, sure.
The next one is order 9.
Thank you very much for bringing that to my attention. So order 9 is appearance. Okay. So now, after you have taken all the steps to bring the issue to the attention of the person, then the obligation is now on the person to appear. Now, this is very important. Take note of something. Unlike in criminal procedure, where the physical presence of the person is very important, as enshrined in the Constitution, which talks about the fact that the Constitution eschews trial in absentia. That means if you have a criminal issue against someone, the person must be in court physically for the person to know what issue you have against the person. That's why sometimes, in fact, in most cases, the person must be arrested. And it is only when the court is satisfied that the person will still physically appear that the court will dispense with the arrest and grant bail. In civil procedure, when we talk about appearance, we are not interested, or the emphasis is not on the physical appearance of the person, but that the person should give us a notice that the person is involved in the case. So a lawyer can conduct that case for the person. So the person need not physically appear, but the person must do something that the court would be or would understand that the person is involved in the case and involved in doing his part in helping the court settle the case. Okay, so when we talk about appearance in civil procedure, we are talking about entry of appearance, which has nothing to do with physical appearance. So in many cases, you'll be given facts where the examiner wants to see whether you understand the difference between what we mean by appearance when we are talking about procedure and what we mean by physical appearance. In civil procedure, we are interested in appearance in line with the CI 47 and not about physical appearance, unlike in the case of criminal procedure. So this is how you learn the law in part 1. Don't learn it in isolation. You can learn it by also contrasting it with what happens in other areas of law, like civil procedure. But never make the error of confusing the two. Once you confuse the two, what you are telling the examiner is that you do not deserve to pass part 1. Okay. The idea is for you to see the contrast between procedure when it comes to civil matters and procedure when it comes to other matters such as criminal procedure. In civil matters, in appearance, we are not talking about the physical appearance of the person, but the entry of appearance. So a person can file entry of appearance and be outside of the jurisdiction, but that person has still duly filed entry of appearance. So that's how you must understand it. We are now on number 10, or order 10, which is about the default of appearance. Again, I want to say that please, if anything is not clear, please interrupt me. Okay, it also helps me. Okay, or if I miss anything, just let me know. Okay, so order 10, and then I want to discuss it together with order 13, which is default of appearance and then defense. Now, here is the point. Once you have been duly notified, remember we said that the whole issue about being notified goes to the root of natural justice. The fact that if somebody has an issue against the person, then the person must be aware of the issue so that the person can come to court, or, as we have said, file an entry of appearance and have the case conducted so that we can hear his side of the matter. Okay. But once the plaintiff has done whatever is required by law and by procedure to bring the issue to your attention, and you still fail to enter appearance, remember that even in trying to bring the issue to your attention under order 7, if he tries to personally serve you and you are evading or being evasive of the service, then you can go for substituted service. and there are conditions for substituted service. It is not something that the plaintiff, by his own discretion, chooses to do. Okay, because these things are not just procedural things, they have a foundation that is rooted in natural justice. So that you just go and try some um, flimsy way of serving the person, and when the person has not really been duly served, you now quickly go to the court and say that the person does not want to answer the claims that you want to bring against that person. That's not what we are interested in. The court wants to be sure that you have complied with the procedure that would ensure that you have tried to bring a thing to the person's attention personally. And it is the person that is trying to evade service. That is why you have come back to the court, and then the court will now allow you to do substituted service. So now, having done everything that you are supposed to do, if the person still fails to enter appearance, then there's a way that we must punish that person. And we are saying that by punishing the person, we are looking at giving a judgment that punishes the person. That judgment is not going into the merits of the plaintiff's claims. That judgment is simply saying that because a person is not giving respect to the court, we are going to punish them. So default judgment, whether it is appearance or defense, because they are not given based on the merits of the claims, the position of the law is that they can always be set aside. You see, because your real cause of action is rooted in the substantive law. So the judgment that you are being given by procedure, it is not really firmly rooted in the law. That means that the other party, once it can provide reasonable justification, can set aside that judgment in default at any time. Because the courts are, and indeed the laws are really interested in settling matters based on the merits in line with substantive law, rather than merely on the basis of procedure, which are only intended to facilitate the determination or the resolution of the issues. Okay, so that is how you treat default judgment, and you should read about the principles of the default judgment under the orders and also in the case law. Now, let me come to pleadings, which is a very, very, very important aspect of civil procedure. Okay, now a lot of people chose to come to law school or want to become lawyers because of watching series like Suits and other things. Okay, and in those series or in those movies, we see a lot of surprise. So the clever lawyer is the one who hides all his evidence, and at some point in the movie, he springs a surprise on the other party, and we think that that person is a very, very intelligent lawyer. That is not how litigation is conducted in practice or in reality. The modern principle is that all litigation is conducted with all cards up, okay? Which means that when you come to courts, the facts that underpin or underscore your case, you must put all those facts in what we call the pleadings. And it must begin with the plaintiff. So the plaintiff must separate. We are not at this point looking at your evidence. We are not at this point looking at your understanding of the law. At this point, you are looking at what are the facts that makes you believe that you have a course of action. Okay, that is why by the time somebody reads your pleadings, they must understand clearly what your course of action is. If people are struggling to see what your course of action is in your pleadings, then they can bring an application to strike out your pleadings under Order 11, Rule 18(1)(a). Okay, so your pleadings are the facts of your case, and it starts with the plaintiff. The plaintiff must serve the statement of claim on the defendant. The defendant must serve a defense in reply to that, or the defendant can have a reply. Okay, or I know. So when the defendant files the statement of defense, the plaintiff must have a further reply. That is, the defendant is raising an issue that is not in the statement of claim, which the plaintiff must respond to. So the plaintiff files a reply. But then, if the defendant, having received the statement of claim, believes that he does not only have a defense but a counterclaim, as I have earlier explained, would file what you call a counterclaim. So a defense and a counterclaim. Okay, so that's all those things goes into what we call your pleadings. Your statement of claim, your defense, your counterclaim, and your replies. These are what you call your pleadings. They are the facts of your case. And the rules of pleadings are that you must plead facts and material facts only. Okay, then you cannot plead evidence, but you can plead what you call points of law. So you cannot plead the law, but you can plead what you call points of law. There are cases where the facts that gives you a cause of action arises only as a result of a provision, just a single provision of the law. So, for instance, when you want to bring an application to refer a matter to ADR, the only reason that gives you the ability to bring that application is that provision in the ADR, Section 6 of the ADR Act, that says that you can bring such an application. Okay, but let me use a better one. So let's say you are a defendant in adverse possession, okay, and then your defense is that you have been in adverse possession for 12 years to the knowledge of the plaintiff who is claiming title. Now, your defense here is a point of law that the action of the plaintiff is stopped under the Limitation Act. Okay, so in this case, your fact is that point of the law. So think about it as the point of a pen or the point of a pencil. You are not pleading the law, but you are pleading that point of the law. So the rules of pleading is that you must plead facts and material facts only. You cannot plead the law, but you can plead the point of the law, and you cannot plead evidence. You cannot plead evidence because there is a separate segment of criminal procedure where we will deal with evidence. Okay, so your ability to draft your pleadings and to make clear the facts on which you rely for your case is actually one of the principles that will make you a great lawyer or set you apart as a lawyer from another lawyer or set you apart as a good student of civil procedure from another student. Because we can all know the facts, but the way you present the facts are important. So in presenting the facts in the statement of claim, the very first facts that you present or the first and second paragraphs are what you call the matters of inducement. In the first paragraph, you must introduce the plaintiff. The second paragraph, you must introduce the defendant. The third paragraph, you must introduce how they came into contact. Because if two people never meet or have any point of transaction or dealing with each other, there cannot be a cause of action, which will cause one person to be a plaintiff against the other person. Okay, so that is how you understand the pleadings. And I want you to pay attention to Order 11, Rule 18, 1A. Okay, what we call striking out of pleadings. I have told you that your pleadings are the facts that display your course of action. And remember that in the beginning of this session, I told you that your course of action is the number one thing that you must know in civil procedure. And that number one thing is not a procedural issue, it's a substantive law issue. That means that if, as a lawyer for a defendant, I receive a statement of claim and I cannot see any course of action in the pleadings, then what I should be doing is not to come file a defense. What I should be doing is to pointing the attention of the court to the fact that the person does not even have the number one. The person does not have a course of action. And in that case, Order 11 Rule 81A permits you to bring an application to strike out the action. So to kill it at birth, you are killing that action at birth. You're not even allowing it to go to trial. Okay, we are saying that that action lacks, number one, it lacks a course of action in the substantive law. So it is not a procedural issue that can be saved by the court, and that the court should strike it out. And in that case, you are allowed to bring that application without what we call an affidavit in support. We'll deal with application later. Okay, that will be a separate session. So pay attention to that when you are learning the Order 11. And please look at your manuals anytime you are reading the orders. The manuals will point you out to the specific rules that you should master. Master those ones first. Even if you believe that you can learn all the rules, there are 81 orders in the CI 47, if you believe that you have that talent, please start from knowing what the manual wants you to know first before you go to the extras, because it is very likely that your exams will be based on what the manual wants you to know first and what your lecturers are pointing your attention to in class before any other details. Okay, so that is what I would say. Now let's go to so we've just done with default of appearance, we've done with pleadings. Now counterclaim, I've already discussed what counterclaims are. Okay, if you also have a course of action, now counterclaims can arise not only because you believe that you have a particular claim under the same course of action, but that you also have a course of action against that same plaintiff. Okay, in that case, you will not wait for that matter. So let's say that you have two contracts. Okay, Mr. A entered into a contract with Mr. B. That is called contract one. And then there was a breach of that contract. So A sues B under contract one. But then B has also earlier entered into a contract with A. B had entered into a contract with A, contract two. It's like still against the same plaintiff, even though it's not the same cause of action, but B still has a cause of action against the same plaintiff. The CI 47 allows you to bring that same action within this matter. So don't wait for this one to be dealt with before you now go and issue your own rates and sue that person. So pay attention to counterclaims under Order 12 and see how counterclaims work. But essentially, like I've demonstrated to you, counterclaims are the defendant saying that not only do I have a defense against the action of the plaintiff, I also have a claim against him. So under the counterclaim, we see the defendant as a plaintiff. So the defendant is a plaintiff under the counterclaim. And then the plaintiff or the original plaintiff is a defendant under the counterclaim of the defendant. Okay. So the plaintiff is a defendant under the counterclaim of the defendant. But then under the counterclaim, the defendant is the plaintiff. So pay attention to those things and master them. Now we are on Order 14. Now, Order 14 is what we call a summary judgment. Now, for me to explain Order 14, please let me touch on the default judgment again. In the case of Order 10, which is the default of appearance, and Order 13, in the case of Order 10 first, your application for the judgment in default of appearance must be that you have duly complied with all the procedure or the procedures that you are required to comply with for the person to enter appearance. That means that you should have duly served the person with a writ of summons and a statement of claim, and in the right manner. The person should have been served in the right manner. And then the 8 days should have elapsed for the person to enter appearance, and the person should have failed. Then you bring an application to tell the court that while you have complied with all that you should comply with, the person has failed. Okay, so in the case of the application for the judgment in default of appearance, you must show in your application that you have complied with everything that you are supposed to comply with, and that the defendant has failed to enter appearance. In the case of the judgment in default of defense, the requirement is that you should have done all your part. Then the person should have duly entered appearance, but must have failed to file a defense within the period, the 14 days that the person is required to file the defense. So you are bringing an application that while the person has entered appearance, which is the right thing to do, the person has failed to enter a defense within the period provided by the law. You must always see the difference, because when the facts are given to you, you should know when you can go for an order for judgment in default of appearance or judgment in default of defense. Now, this is where summary judgment comes in under Order 14. In the case of summary judgment, right, the person should have duly entered appearance. Now, it can be that the person has either filed a defense or not. So in the case of summary judgment, you are saying that whether or not the person has filed a defense, it is your respectful view that the person has no reasonable defense in law. So whether or not the person has filed a defense, you are bringing an application that on the face of your pleadings, the court should see that the person, whatever defense that person has filed, or the failure by the defendant to file a defense is an indication that the person has no reasonable defense, and the court should not bother going to trial. But then just at this point, the court should give you judgment. So imagine that you are giving a loan, Mr. A has given a loan to Mr. B. And the purpose of the loan was for Mr. B to go and do business and repay the loan. The time for repayment of the loan has elapsed. And when Mr. A sued Mr. B, he served the writ of summons and the statement of claim. In scenario 1, Mr. B filed a defense, and in the defense said that he used the money for betting, okay, for betway betting, and the bets do not go through, and because he has failed to win the bet, he has not paid. And until such a time that he wins a bet, he cannot pay. That is not a reasonable defense in law. So in such a case, the plaintiff must not wait to go to trial. The plaintiff must bring an application for summary judgment and say that the court should see what defense this person has filed and look at what pleadings you have filed. And on the basis of the pleadings that you have filed, determine that that person has no reasonable defense and there is no need to waste the time of the court in going to trial to determine the matter. And that on the face of the pleadings, the court can give a final judgment to the plaintiff. Now, what it also means is that the plaintiff will have the equal burden of proving his case as if the matter was supposed to be in trial. Okay. Now, remember that the summary judgment can be brought whether or not there has been a defense filed by the defendant or not. So there's a small point of overlap between the application for judgment in default of defense and summary judgment. But this is the test that you must run. Okay. In the case of the summary judgment, it can apply even if the person has filed a defense. But in the case of judgment in default of defense, the person shouldn't have filed a defense. So if you have given any set of facts which says that the person has filed a defense, then you have no business going for application for judgment in default of defense, because you have been told that the person has filed a defense or has duly filed a defense. But then if the facts let you know that the person has duly entered appearance, but then has failed to file a defense and then the period for filing defenses has elapsed, then that is where you have a window to either go for judgment in default of defense or summary judgment. But then take note of this. The advantage in going for the summary, the judgment in the summary judgment is that the summary judgment is considered in law to be a final judgment. So unlike the default judgments that are not given on the basis of the merits, but on the breaches of the procedure, the summary judgment goes into the merits. So it is a more binding judgment and it is more difficult to displace. Okay, so if between going for the summary judgment and the judgment in default of defense, you are able to go for any of them, then you must actually go for the summary judgment. So in exam, if it is possible that per the facts, you can actually go for a summary judgment, then that is what you must be drafting first. The one who will be drafting the judgment in default of defense will lose marks. Okay, but there is also something that you must pay attention to. There are certain actions that in any case or in any event, you can never apply for a summary judgment. No matter how ridiculous you think that the defendant's defense is, or even if the defendant has failed to file a defense. And you will find those things in Order 14, Rule 12. So pay attention that you always exhaust it. So if in the set of facts, there's actions under Order 14, Rule 12 have been listed, then please, the last thing you should be thinking about is summary judgment. And it includes things like probate, marital issues or matrimonial issues, maritime issues. And then the real principle is that, the underlying principle is that in these cases, no matter how much you think that the other party's defense is unreasonable, it is still important that we hear their side of it, of the matter. Okay, because in a matrimonial issue, you may have all the reason to think that your spouse does not have any reasonable defense, but please, the court still is interested in hearing what their side of the matter is. Okay, but there can be an issue of contract, for instance, where on the face of it, the court can actually determine that the other party does not have any reasonable defense. So pay attention to this. If there's any question on this, please let me know. Okay, and in drafting the application for summary judgment, one of the differences, and I said we'll talk about application, so I'm not going to go too much into it. But one of the defining things is that this application must have the reliefs on the face of the application. Later, when we discuss applications, you understand what I mean. Because generally, applications do not have reliefs on the face of that application. Whenever we talk about an application, it consists of three things, and that's all I'm going to mention for today. It consists of what we call the motion paper, the affidavit in support, and the certificate of exhibit. I'll deal with these things later on. I want to quickly make sure that I exhaust the 25 orders for today. So we now go to Order 15, okay, which is the third-party procedure. You remember that when I was discussing joinder of parties, I mentioned how the third party becomes a part of the action. there is no privity of contract or privity of action between the plaintiff and then the third party. Okay, so anytime you see from the facts that the plaintiff can only have an issue with the defendant or a person who can be a defendant, then they are the people that you must join to the action as the defendant. Okay, but then the plaintiff cannot join a third party. It is the defendant who can join the third party because the privity of action exists between the defendant. That arrow can be thrown between the defendant and then the third party. So always remember the throwing of the arrows. The plaintiff throws his arrow to the defendant or defendant, but the defendant can only throw his arrow either as a counterclaim to the plaintiff or as an action to the third party. The plaintiff cannot throw an arrow to a third party. So if the plaintiff can throw an arrow against anybody or can bring a claim against anybody, then that person must be a defendant. And that person must be a person whose presence is necessary for the final and effective determination of the matters in dispute, not necessarily anybody who has an interest in the action. Please remember that it is not necessarily anybody who has an interest in the action, but a person whose presence is necessary for the final and effective determination of the matter. So your husband may be interested in a suit against you, but then your husband's presence in that matter may not be necessary for the final and effective determination of that matter. So in this case, your husband or your wife cannot be added as a defendant. So pay attention to that. Okay, now we are on the order 16. So again, when I started this session, I said that there are important things that everybody must know when it comes to civil procedure. There are only 5 things that you must know. The number 1 is how to understand what you call a cause of action. Number 2 is how to understand what you call jurisdiction. Then procedure starts from number 3, which is how to initiate the action. 4, what to do during the proceedings. And 5, after you've obtained judgment, how to enforce the judgment, or if it went against you, how to file an appeal. Now, under order 16, the point is that when people generally make mistakes in procedure, we are saying that the effect of that mistake should not be as drastic as if the person lacks a cause of action under number 1, or if the person takes the action to the wrong courts or the court that does not have jurisdiction under number 2. We are saying that if the person that lacks a cause of action under number 1, that person has no business being in court. Okay, so if as a lawyer, a client comes to your office and you are not able to understand what cause of action is and you're always running to court, it will not take long for other lawyers to know that you don't know what you are about. Because every time your actions will be struck out. Because the other lawyer would always bring an action to an application to the court to strike out your action because the number 1 has not even crystallized. Okay, you don't even have a cause of action. Now again, if you know how to identify a cause of action, but then you have an action that you must take to the High Court, but you go to the Supreme Court asking for Chief Justice Tokonu, then that means that you also do not have any business either being in court or probably being a lawyer, because your action will be struck out without the court going into the merits of your matter. In that case, the court said, yes, you have a cause of action. You were brilliant in school. You understood what cause of action is, but that is all you bothered to know about. You did not go to the number 2 to understand what jurisdiction is. Okay, so you must go back and learn those things before you actually come to court and present people's cases. Under number 1 and number 2, you cannot, even the courts cannot save your action. Even if they entertain it, it can be set aside at any time by any other court, because the laws that empowers the courts says that an action should not be entertained if there's no cause of action and the jurisdiction of the court has not been invoked. So this is where order 16 comes in. Order 16 is saying that, yes, the person has a cause of action. The person has identified the right court. But as human beings as we all are, they say to err is human. We all make mistakes. Even the judges make mistakes. No judge is God. Okay, the judge is not God. The Chief Justice can make a mistake. Every judge can make a mistake. Lawyers can make mistakes. Does someone have a question? Okay, so everybody can make a mistake. So we are saying that the procedure which is supposed to facilitate the means by which we bring an action should give us a means by which where someone has made a mistake in good faith, or even a judge has made a mistake in good faith, we would have rules by which that mistake can be rectified. Okay, so there can be an issue where, okay, on my screen I can see Kweku and I'm sure it is Haifa. I hope I pronounced your name correctly. Okay, so Haifa has a cause of action against Kweku. Haifa has been able to identify the court that has jurisdiction, which maybe might be the High Court, rightly. Okay, but then in writing the name of Kweku, Haifa mistakenly spells that name as wisdom for some odd reason. Okay, but from the pleadings and from everything, Kweku knows that that action is against him. Okay, but Kweku now brings an application to say that my name is not wisdom. The writ of summons and the statement of claim that I have received is in the name of wisdom. So I believe that Haifa has no cause of action. In this case, Haifa must demonstrate to the court or must file an affidavit in opposition to the court and say that I indeed have a cause of action. The person I intend to bring the cause of action against is Kweku, and he knows it because he's the one that I had the transaction with. I don't really know his full name, and I may have made a mistake genuinely in writing his name to spell his name as wisdom. But to every intent and purpose, he knows that he's the one that I have the action against. In this case, we have what we call a misnomer. Okay, so Haifa must bring the affidavit in opposition under a misnomer, which is discussed under Order 16 under amendment. So what Haifa will be telling the court is that what I have done is only to misspell the name of Kweku. It is not that I do not have a cause of action against him. And he's saying that he is not wisdom. It's only a ploy to hide behind cause of action. But he knows that he's the one that I had the transaction with. That he cannot hide from the fact that there's a privity of contract or action between us, and that it's my cause of action is against him. Okay, so recently when I was doing my internship with a law firm, one of the very first cases that I had the opportunity to witness was such an application where the defendant was bringing an application to strike out the action of the plaintiff because he says that the plaintiff does not have a cause of action against him because the name that has been put on the writ of summons is not his name, and that he doesn't know what that name is, and he cannot answer to that name. Okay, but then the plaintiff's affidavit in opposition says that, my lord, yes, the person may be right in saying that he's not that by that name, or the name there's a spelling error, or I've written a name that is not him or her, but he knows he cannot deny that the facts that I have put in my pleadings are about him or her. That's one he cannot run away from. So it is simply an issue of an error in the name that I have put there. And it's not a fact that I have a lack of cause of action. And you see that these people, the defendant here, or the plaintiff here, understands what a cause of action is. If you don't understand any of the 5 things I keep on talking about, then maybe you just be called to the bar and forget about this business of the law. Because that is what everything is about. If the lawyer who was representing the plaintiff is not really sound about the number 1, then you would have admitted that, hey, then we've lost our action. And then that application would have succeeded by the defendant. And without erecting any defense, that defendant would have succeeded in striking out. That is, if the court is also minded to agree with him, because sometimes the court will also intervene anyway. Okay, but in the adversarial nature of our system, the court will typically allow you to make your own case, and the failure to make the case is on you. Okay, so that's the things that you must clearly understand. So under Order 16, this is where errors are rectified, including even the errors of the judge. So please master it. And the principle is that when you want to bring an error to the attention of the judge, you must demonstrate that the error is an error that has been made in good faith. That it is not because you have seen, after serving your pleadings to the opponent and after receiving the opponent's pleadings, you now saw how weak your case was, and you want to run and go and find a way to now amend your case. So remember that under Order 11, there's what we call rule against departure. And because I have also mentioned that under modern litigation, there is nothing like surprise. We go to court with each party knowing the other party's case. Not only do we know the other party's case, we must know the other party's evidence. Okay, so that if the other party wants to run away from their case, you must be the opponent must be the first person to know and prevent that person from running away from the case that they have saddled you with. Okay, so if the person wants to use the channel of amendment to create a new case from their original case, this is where the opponent's lawyer must be alert. So civil procedure is almost like a game of chess. And if your procedure is not good, you would have all the course of action under number one. You'll be able to identify the jurisdiction of the court that must hear it, but people will be using procedure to defeat your action every time. Okay, so that is why you must master it, and that is where amendment comes in. Now we come to 7, withdrawal and discontinuance. This is what we want to say under withdrawal and discontinuance. It is possible that after filing an action, you have a change of mind. But then you cannot be allowed to change your mind the way you want. Because when you file an action against me, I will probably begin looking for a lawyer. And that is why we are training to become lawyers, because as lawyers, our business will be the law. Once somebody comes to see you for consultation, already you are charging the person for consultation fee. Okay. So it means that if the plaintiff wants to at any point discontinue and withdraw their action, they cannot just say that they have decided to withdraw their action, especially when the statement of claim and the writ of summons has been served on the other person. What about the cost that that person has incurred in hiring another lawyer, or that person in coming to you to give you the statement of claim and the writ of summons, and you charging that person the consultation fee? Who would now pay for that consultation fee? That means that the defendant would have incurred a cost which that plaintiff who has withdrawn the action must be liable for. So there are rules about how you even withdraw the action before the action even goes to trial. You cannot go and file an action against somebody, go and sleep and have a bad dream and say that you are just withdrawing the action, and then the defendant will just be happy with you. Okay, because the defendant may have taken steps to also find or file a defense, and those steps would involve costs. And so there are ways by which you can withdraw an action, which includes a reasonable compensation to the defendant, depending on where the case has gotten to before trial. So you pay attention to withdrawal and discontinuance. You can't withdraw once you have duly served or you have duly initiated your action, there's a means by which you can withdraw or discontinue before the matter comes before the trial judge for hearing. Remember that in all these things, the mere fact that you have filed an action does not mean that the action is before the judge. All this while, the thing is going on and on between you guys. You've served the person with a statement of claim. The person also serves a defense. There can be replies. There can be statements of, there can be counterclaims and that. Once those pleadings are over, there's close of pleadings, and then there will be other things. I'll discuss those other things in the subsequent sessions. Okay, so the mere fact that you have initiated an action does not mean that the action is before the judge. We will see where the action actually comes before the judge. And because some of you are doing internships, you know some of these things. Okay, so that is how order 17 comes. Now we come to order 18. Okay, so let's say that somebody has filed an action, Mr. A has filed an action against Mr. B. Now it is bordering on breach of contracts. Now Mr. B says that, see, I will pay you the money that you're asking for. Don't let the thing go to trial. I'll pay you the money that you're asking for. There is a means by which that money must be paid to court to the extent that A has already initiated the action. Okay, you can't just go and see A on the side and just pay A the action and tell the court that the thing has been settled. And the good thing or the advantage about paying payment into court is that if you allow the matter to now go to trial before you want to settle the matter, the court may still allow for the settlement subject to costs, because that plaintiff went to hire a lawyer. But typically, if you make the payments to court before the matter comes to trial, then issues like cost will usually not come up. Okay, or they'll be highly abated in a way. Okay, because this is something that you are settling with the plaintiff before the matter actually comes to trial. So there are rules about how you make payments to court, and there are general payments. And so anything that talks about making payments to court. And remember, when you talk about bail, bail is not, even though bail happens in criminal actions, the bail application itself is a civil thing. Okay, that is why we say that bail is a contract between you or the what's the name, the one who stands in surety, and then the state. And it is not a criminal thing. That means that if there's a breach of the bail terms, it's like a breach of contract. Okay, so payment in courts to court under bail and all those things, you see that it is defined by court rules, and it's not really criminal procedure proper. Okay, so this is, if there's any matter about payment to court, you go to order 18. Now, order 19 is something that you must master. You must understand it inside and out. You see, with procedure, you can't run away from it forever. Even if you pass your civil procedure exam. A friend of mine was telling me about doing their internship in a particular court. And the judge was talking about how when she was in school, procedure was really difficult for her. Okay, but the point is, she's able to be a judge because she has overcome that problem. Until you overcome your issue with procedure, and particularly this order 19, and this thing we call application, it will always be an issue. An application is a very simple thing, but it's a very, very, very important thing when it comes to procedure. Because you hear about application in criminal procedure as well. You even hear about applications under company law, under ADR. There is nowhere that you will not hear about applications. Maybe, probably, maybe in accounting, that's where you not hear about application. Because an application is that instrument that can bring you before a judge, even before your substantive matter has brought you before the judge. It can bring you before the judge before trial. It can bring you before the judge during trial. It can bring you before the judge after judgment. So it is always the instrument that can bring you before the judge. And it is something that you must really understand and know how to draft and know what goes into it. I'm going to take my time and explain that in a subsequent session, because the truth of the matter is that in part one can be as easy as it's difficult. Because if you really understand how an application is, then when you are doing criminal procedure, you'd also be able to apply it by adjusting that understanding to the context of criminal procedure. In the same way, when you come to ADR, you say that you are learning application in ADR. No, you are applying your understanding in applications as you generally understand it to ADR, because the applications in ADR are not different from the applications that we are talking about. It is all procedure, and it is all with reference to what you are learning in civil procedure. Okay, so you adjust it to see how it will be different when it is ADR. For instance, when it is an application to refer the matter that is before the court to ADR, or in company law, when we talk about derivative actions, where a director must bring an application, it's the same understanding. So you see, for you who do not understand, you may think that you are learning one thing for company law. You may think you are learning one thing for criminal procedure, another thing for criminal procedure, and another thing for ADR. But the one who understands simply knows that it is that one thing that he or she understands, and is just adjusting that understanding when it comes to a different area of law. That's why I keep on saying that in part one, you can find yourself learning many things, or learning one thing and adjusting your understanding for each area of law. And that's really what you must do. Because, like, as the director of the Ghana School of Law has given us the advice I shared in the beginning, you must see yourself not as law students, but as professionals or as lawyers in waiting, who are waiting to undertake the final portion of your practical studies to become lawyers. Okay, so if you're not seeing these things as tools that you'll be using in the court, and you're just seeing them as theory that you'll be using to pass your exam, then you may finish and you struggle. Some people will tell you that in practice, you learn everything. A managing partner of a firm told me the people who tell you that they are learning so many things in practice than what they learned in school are the people who did not take their time to understand the practical aspects of the theories that they learned in school. If you take the theories seriously in school and understand the practical aspects, you will not find a wide gap between the practice or what is happening in practice. In fact, while you are going to the courts and doing your internships, you will see the connections between what you are learning in class and what is happening on the field. So that is for applications. We'll discuss it specially. Now we come to Order 20. Order 20 talks about affidavits. Okay, now the good news is this. An affidavit is a component of what we call an application. And sometimes you also hear lawyers saying that, oh, I'll bring a motion. I'm going to bring a motion against this other party. What they actually mean is that they are going to bring an application. A motion is under an application. An application has three components. The first thing is the motion, which is on the motion paper. The second thing is generally the affidavit in support of the motion. And then the third thing is what we call the certificate of exhibit. In the subsequent sessions, when we deal with applications, all these things will become very clear to you. Okay, so an affidavit is a component of an application. A motion is a component of an application. And what lawyers bring is not the motion, they bring an application. Okay, and under the application, they move a motion under that application. Okay, so settle this thing once and for all. The application is made up of three things, which is the motion paper, the affidavit in support, and what we call the certificate of exhibits. Okay, and that's so all these three things come together to form the application, and we'll discuss it later. Now we come to Order 21. Order 21, as the name suggests, is discoveries. When I was in secondary school, I had a friend who said, very intelligent friend, even if he has no idea about something, he will pay attention to the name of the thing. The name says discoveries, and I had said it earlier that in modern litigation, or in litigation as it is in practice, unlike what we watched in the movies before we came to the law school, it is about, or it is conducted with all cards up. There's nothing like ambush litigation again in our courts, where an intelligence lawyer will hide evidence and then will spring it as a surprise. And then you see this thing in your evidence law as well. Okay, that unfair surprise under Section 52 is not allowed. Okay, so in the discovery stage, even before the matter goes to trial, is the stage where the parties, after they have seen each other's pleadings, must now exchange the evidence that they have in support of the pleadings. And so that's why I keep on telling you that in part one, you don't learn any subject in isolation, because your understanding of discoveries will also firm up your understanding in evidence. Okay, so the person who takes it like that will always be learning one thing for two, or killing two birds with one stone. And in fact, it can even be many birds in this case, because you can be killing like 6 birds with one principle. The point is that discovery is a stage where, after the close of your pleadings, you must now meet with the other party and exchange that evidence that you'll be adducing in court to support the pleadings that you have exchanged. So you go to court not only knowing the facts of your opponent's case, but knowing the evidence that your opponent must be provided, such that if your opponent has made a pleading, has made an averment of fact in their pleadings, you must know that they must have evidence for that fact, and it's at the discovery stage that you must see it. And you don't object to it at the discovery stage, because in a recent Supreme Court ruling, they have said that evidence must be objected to when it's actually adduced at the trial. So you make a note of it, that when when you get to the trial and the person wants to adduce that evidence, you now object to that evidence because you've had prior knowledge at it from the discovery stage. So you see how bad it is if a lawyer fails to object to evidence that must be objected to. That means that that lawyer must have been sleeping on his duty from all these processes, from the pleading stage, from the discovery stage. Because before you go to court, before the trial begins, you must know what you want to do against your opponent. And you must not allow the evidence to slip through and be adduced and be accepted by the court. Before later on, when you are going for appeal, you say that that evidence was an unfair evidence, or it was an unfair surprise. You see, so this is how you can actually see how good lawyers are made, or how good students of civil procedure are, and then those who just want to be part of the crowd, or just want to follow the crowd. It's very important that you settle these things with you and you get it clear. So that's for discoveries. Okay, those are the rules about discoveries. Then we go to interrogatories. Now, I spoke earlier about pleadings, which are the facts of your case. Sometimes it can be that after you have served your pleadings to the other party, the other party will now say that, see, my name is Felix Aboagye, and you have served a writ of summons and a statement of claim in the name of Edward. Let's say Edward Kweku. I am not Edward Kweku, even though I know to every a reasonable thing that I must know from the actual facts that the thing is against me. Okay, that the person has a cause of action against me, I will say that I am not that person. Because I am not that person, the plaintiff should be denied the cause of action. In such a case, the plaintiff can bring an application for what you call interrogatories. And in the interrogatory, he just wants to serve a question on the other party. And the answer to that question will determine whether he's dealing or he or she is dealing with the right party or not. So, for instance, let's say that fraud, your main case is that is bringing an issue of a transaction, a breach of contract, and the entire transaction was done on WhatsApp using a particular number. Okay, now you filed your action against whom you believe to be the owner of that number, but the owner is saying that the cause of action does not arise against him or her. So now what you want to do is to bring an application to serve to serve interrogatories on that party to say that you want that party to just answer to the question, does so and so number belong to you? Is it registered in your name? Once the person admits that the number is registered in their name, then you have all that you need to know that it is the right person. Then that person is only hiding behind maybe an error in the spelling of the name or something, which can be corrected under Order 16, under amendment. It is not indeed the case that you do not have a cause of action against them. Okay, so that's how you use interrogatories. And the rules by which you can serve these questions come under the interrogatories, which is Order 22. Now we have what we call admissions in civil actions. Admissions are like confessions in criminal actions. In criminal actions, we have confessions, but in civil actions, we have what we call admissions. You cannot have a confession in a civil action. You can have an admission. And you know about how to um, file or how to draft a statement of defense. You know about the general traverse. Whatever you do not deny, the principle is that you have admitted it. And that is why what you call the general traverse is a very, very important thing. The part that says save us hereinafter um, admitted. The defendant denies each and every averment contained in the plaintiff's statement of claim, as if same were set out in extenso and traversed seriatim. You can put it in your own words, but the essential point is that apart from anything that has been admitted, the defendant denies anything that is contained in the plaintiff's statement of claim. Okay, so that even if there is an oversight, it should be taken that the defendant has denied it. The point is that if you fail to deny any averment in the statement of claim, the plaintiff need not wait for trial. Even on the other averment or on the other reliefs, the plaintiff can bring an application for judgment on your admissions, on the aspects that you have admitted, and then can obtain judgment on the aspect that you have admitted. And even then, when there are multiple defendants, where one defendant has admitted their part, you can bring the action for judgment for admission or for that defendant while you pursue the rest of the action or the action with the other defendant who has denied or who has filed a statement of defense. Okay, so that's for admissions. Now we go to 24. Order 24 talks about security for costs. There can be situations where a plaintiff is bringing a matter against you, which you believe that it's really a malicious action. If you can satisfy the court that this is such an action that is being brought against you, the court can require the plaintiff to deposit costs in the first place before the matter is even heard. Because at the end of the day, if the defendant wins this thing, the court would apply for costs. I know the cost would be paid based on the how you can enforce the judgment. When we get to enforcement, you understand. Because if the person is a poor person, you can't really enforce a judgment against that poor person if it is monetary. Okay, if it's about money and you cannot have anything to attach from that person, you would have obtained a judgment that you call brutum fulmen. Okay, a judgment that you cannot really enforce or that you cannot really apply. Okay, but in this case, you would have still brought a great deal of inconvenience to this defendant who would have been a part of the entire trial. Okay, so in such a case, the court can require that there is deposit for costs even before the action is initiated. So the principles or the procedures that regulates that is under Order 24. Now, Order 25 deals with injunctions. I had said earlier the importance of bringing an action to the notice of the other party, which is under Order 7, right? Service. Because it goes to the root of natural justice, which also goes to the number 1 point of the 5 points that I've said we should understand, which is about the course of action. That if you have a course of action against somebody, then that person that you have the course of action against is entitled to know that issue that you have against him. And there must be a procedure by which you let that person know. Okay. Now, after that person knows that thing, the person can now enter a defense. But there can be situations. So that means that all actions must, in a way, be on notice to the other person. So even if it's an application, the general principle is that the application must be a motion on notice. That's why I always say I prefer to call it originating motion on notice, because it reminds me that I must put the other party on notice, and that is the general principle. But there can be certain situations that somebody is encroaching on your property. Every day you go and see that the person is really building, but they only build at night. So you don't know the exact person, but definitely this is not a ghost. It is a human being, or it is an entity that can be a person in law. Okay. But in the meantime, you have not identified that person, but you still have a course of action. You know that that course of action is against a party. It is just that you don't know the person's name and address. Okay. So you want to first stop what is going on before you now clearly identify the person and bring the action against him. So you apply for an interlocutory injunction. Okay. And that application is ex parte. Because in this case, it cannot be on notice to the person that you don't know yet. Okay. But when you stop it, when you stop that action from going on, you can now take your time and get that person that must be the proper party and bring the writ action itself against that person. So you also see that generally all applications, when they say application for leave, application for anything to do anything, primarily you must be thinking about it as that application being on notice. So that even in ADR, when we say that an application to refer a matter that is before the court, you must understand that that application must be on notice. It is not an ex parte application. But then if you think of an application like application for substituted service, it cannot be on notice because your whole argument is that you've been trying to bring this matter to the notice of someone, but the person has been taking steps to also evade service. So definitely the person that you have not found, you cannot put him on notice when you are bringing that application for substituted service. So it must definitely be ex parte. So these are some of the clues that will help you to understand whether the application that you are drafting in the exam must be ex parte, must be ex parte, or must be on notice. The fundamental principle or the default principle is that generally the thing must be on notice to the other party so that the other party can also file an affidavit in opposition. So if you are bringing an application where it is an ex parte application, in your mind, you should have settled why it is an ex parte application. And so you must understand injunctions under Order 25 and the principles that go with injunctions. And you must understand. So we bring it to an end here. It is 10:07, and we have discussed from Order 1 to Order 25. Remember that we also discussed Order 82 and Order 81. Once you have a general good understanding of these things, you really would be fine when it comes to number 3, which is how to initiate an action in a civil matter. You'd really be versed in the principles that you must know when it comes to the number 3 out of the 5 things that you must know. Remember that I have said for number 1 and number 2, it is not really the business of Ghana School of Law. There are things that you should have known from the faculty, so that even if you feel that you are still deficient in that area, you can go back to the substantive law and satisfy yourself. For course of action, you can read about Litang versus Cooper. It discusses how you identify a course of action. Okay, substantive law, for instance, if you think that your company law is weak, because if your company law is weak, it will be very difficult for you to understand courses of actions that affect a company. Okay, they will tell you that somebody has a contract with a company and you'll be thinking about suing the managing director or suing the employee, who are not the right persons. The persons you should sue is a company because the company is a person. Okay, then you must also revise your jurisdictions. Go to your constitution and go to your court act and revise the civil jurisdiction of the courts. Okay. But then procedure starts with 3. And for all this evening or tonight, all we've been discussing, all the things we have discussed is about 3. That is how to initiate an action. And the orders that will help you give you a fundamental understanding of the principles that you should know when it comes to initiating an action. The more of the rules that you know under these orders, the stronger you become in terms of how to initiate an action in a civil matter. So this is why we bring the end of the session. Let me know if you have any questions. Otherwise, our 2 hours is exhausted for today. Okay. So please, is there any question? Does anyone have any question on what you have discussed so far? Or is
Yeah.
everything clear?
Hello,
Yes.
Felix.
Yes, sir.
Yeah, thank you very much for your wonderful presentation tonight. Some of us joined late, so if you can re-mention those 5 pointers that you base your discussion on briefly, just list them for us. So, hello.
Hi, Edmond. I just hold on. I think his network is messing up. But what he stated was that there are 5 key things that concerns civil procedure. The first is that you must identify a course of action in a civil matter, right?
Yes, exactly.
Okay, so he's
Okay.
back.
Okay, sure. Sorry for the hiccup. Okay, so Edmond, I said it at the beginning, and thankfully Fatah is recording this session. So for those who joined late, you can listen to it. Civil procedure, it only requires you to understand just 5 things. Everything that you are doing in class, everything in CI 47, everything in your manuals can be grouped under just 5 things. So even if you are saying that you are overwhelmed, you are not getting what civil procedure is about, I'm saying that your excuse is taken away. All you need to remember is that civil procedure is just about 5 things. So you should go to the exam hall armed with these 5 things. Somebody will go thinking about all the principles. Then these 5 things are these. Number 1, how to understand what is a course of action in a civil matter. Number 2, how to understand which court has jurisdiction in the matter. Okay, somebody has even put it in the chat. Number 3, how to initiate how to initiate an action in a civil matter. Number 4, what to do during the proceedings. And number 5, when you have obtained judgment, how to enforce the judgment on one hand, or the judgment went against you, how to file an appeal. Now you see, let me just take number 5 for instance. Number 5 is so important because in company law, you study, there's a case called PS Investment, Force versus Harborton. In that case, at the trial court, he lost the matter, he lost the action. He took it to the appeal court. He lost the action again. And then he took that matter to the Supreme Court and won. And it has become a major case for us to study at the Ghana School of Law. Imagine if this person knew the course of action and he knew the jurisdiction. He initiated the action perfectly. He knew how to conduct himself. But then when the action went against him under number 5, he didn't know how to file an appeal. We would all have been denied the benefits of such an important principle that we have learned or will learn in company law because that lawyer did not know how to file the appeal and get the fruit of the course of action that his client deserved, even though the trial court had erroneously decided that the person did not have a course of action, and then the appeal court had extensively argued that the person did not deserve that course of action. And it had to take the Supreme Court to say that no, the person indeed had a good course of action, and that it's the court that erred in the judgment, and on appeal, they reversed the decision. So your civil procedure must be strong around all these 5 points. Everything that you'll be learning is something that you can situate under one of the 5 things. But I'm saying that for number 1 and number 2, there are things that you should have known at the faculty. So if you are struggling with them, it is because there's an issue with something that you did not really pay attention to at the faculty. But all hope is not lost. You can learn about issues about how to identify course of action by paying attention to the principles in the substantive law. Then, for jurisdiction of the courts, All you need is your constitution and then your court act. Everything must be in there. There are some allies too, but at least 80 to 90% of what you need to know is in the constitution and then the court act. Once your foundation is strong, in everything, it starts with the foundation. If your foundation is weak, you can never repair it at the top of the structure. If your foundation is weak, the first thing you must do is to pull down the whole structure, go to the foundation and correct the foundational error before you start putting up the building. Or, as we know with buildings, when the foundation is weak, one day that building will collapse and it will kill somebody. In the same way, if you don't repair the issues that you have with your foundational understanding of civil litigation, you go to practice and you'll be worrying people, your clients, taking people's monies and be doing a poor job for them. Or maybe immediately with the exams that you write, you have a lot of problems that you shouldn't have. Okay, but the good news is that you can actually master all these things once you can tell where your problem is. Is your problem with number one, how you can identify a course of action? Is your problem with number two, how to identify jurisdiction and know that jurisdiction is not a matter of procedure. So there is no need for you to confuse it with order three, which talks about venue, which is just a procedural matter, which must come under number three, because number three is where you initiate the action, and procedural matters begin from number three. Okay, or is it a matter under number four as to how you are conducting the case? Okay, like discoveries. Yes, you have filed the action, but do you know that in modern litigation, there is nothing like what we were watching in the movies, where the other person can hold on to their evidence and spring a surprise on you, and everybody will be like, wow, what a great lawyer. We don't do that anymore. So you know that after you file the action, there's discoveries. And in fact, if the other party fails to discover a document, you can bring an application to compel them to either discover that evidence or for the courts to rule that if they adduce it in the proceedings or at trial, that evidence must not be admissible because it goes contrary to Section 52 under the Evidence Act, which tells you that unfair surprise is one of the grounds where, even where the evidence is relevant, the court can still decide not to adduce it. So you see, it deepens your understanding not just in civil procedure, but then in criminal, in evidence as well. I always say this, you see, I don't know how to cook, I don't know how to prepare soup, but we can take a cue from those who know how to cook very well. Don't take the law as ingredients that are separated. Take it as ingredients that you can bring together to prepare a very delicious soup. It's either the law is with you as soup or the law is with you as ingredients. For you, then, if it's with you as ingredients, every time it is bits and pieces. But for the one who understands the law as the soup, who knows that he can bring everything together, evidence, civil procedure, criminal procedure, ADR, everything, and still see the separations, because the good cook knows the parts of the amount of sauce that they must use, the parts of the amount of pepper they must use, tomatoes and everything. Okay, but they know that if they bring it together, then they have the holistic understanding of the law. And that's how you must proceed or understand your civil procedure. But for just civil procedure, just understand it. It's just 5 things. Somebody has put it in the chat. There is going to be the recording. Remember how to identify a cause of action, jurisdiction, how to initiate an action, which I've spent all night discussing. So in the subsequent discussions, I'm going to discuss what to do after you have now filed the action. Okay, so that's going to be the number 4. I'm going to discuss number 4. And then if we have another session, it will be on number 5. Then we can now have a session on maybe just drafting and how to answer questions. Okay, so that we'll be ready. So if there's any other question, otherwise I don't want to take too much of your time too, because I know you have to study. So please, is there any other question? Hello?
Hi, Felix. It looks like
Yes,
there's
Fatah. Okay,
no.
great.
So thank you so
Okay,
much for your time.
thank you too.
And colleagues, will continue hopefully tomorrow. Take care and good night.
Okay, Fatah. Thank you.
Thank you, Fatah.